Good afternoon, and thank you all for joining us for this afternoon's webinar entitled Preparing for New Federal Vaccine Mandates, What Businesses Need to Know. My name is Ray Van. I'm an attorney here in Carlton Field's Washington, D.C. office, where I practice labor and employment law with an emphasis on EEO non-discrimination and federal contractor compliance. With me today is my colleague, Katie Bell-Bremer, who's a lawyer in our Tampa, Florida office. Katie is an experienced employment law litigator whose practice includes representing and advising clients on state and federal employment law requirements across a number of industries. So I'm so pleased to be co-facilitating this webinar with Katie. We're looking forward to a lively and interactive program today, and certainly welcome your questions. We have a lot of ground to cover, but we want this program to be as interactive as possible. As this slide indicates, this webinar is being recorded for educational and training purposes. The recording may include questions and poll responses provided to you during the live event. And the recording will be made available after the conclusion of the live event and posted to Carlton Field's website. So with that said, let's jump in and hit the next slide.
Thanks, Ray. Appreciate everybody jumping on board today. I'm sure you all have a lot of questions, and we'll try during the course of the presentation to be answering them as part of the materials, but certainly we'll be taking your questions, as Ray mentioned. Our agenda for today is fairly simple, although it's got a lot of material, but we're going to first review and analyze the recently enacted federal COVID-19 employee vaccination mandates, including a discussion both the status and the implications of some of the recent legal action that has occurred in various jurisdictions. Our hope, as well as we talk through this, is to address the practical issues and considerations that you face as employers in implementing these mandates, as well as trying to offer tips and strategies for ensuring compliance and minimizing risk. One of the things we will cover towards the end of the webinar presentation is the obligations of employers to analyze reasonable accommodation requests, both under disability factors under the Americans with Disabilities Act, as well as the religious accommodation requirements of Title VII. So if you bear with us, we will be addressing those topics. Let's get started. What are the mandates? Basically, in a nutshell, we're talking about four different recently enacted pieces of administrative regulation. We start with actually an emergency temporary standard that was issued by OSHA in this past summer in June of 2021. And we start here not because this particular ETS affected all employers. It was really directed towards healthcare, but it also, and nor did it actually mandate vaccines, but it really was a regulation that dealt with the transmission of the disease and to try to stay and stem the transmission of the disease, at least in the healthcare setting. So it set the stage for what we then saw in the subsequent mandates and rules that have been issued. And the healthcare ETS that was issued this summer also provides background for determining if you're an employer who's on this call or otherwise that is covered by multiple regulations. It helps us piece where you fall and which particular regulation will be your primary focus. The second, of course, was issued in September of this year and was the first really of the executive order. It was an executive order different from the other mandates, but applies to safety protocols for federal contractors, EO 14042, and Ray is going to discuss that in more detail in a little bit. We have, of course, the one that probably applies to the majority of folks in this call, or a large majority of the participants, which is the OSHA's emergency temporary standard to mandate vaccines and or testing requirements for employers that have 100 or more employees. That regulation, although announced back a few months ago, was published and effective on Friday, November 5th of 2021. And the on hold relates to the litigation out of the Fifth Circuit as well as in other circuits, and we're going to be talking about the litigation hold and status later. And finally, the last focus of our presentation today, although it applies to healthcare facilities, is very relevant to a large sector of the employer population. In fact, it covers, if I looked at the statistics, 17 million healthcare workers. The number may be more than that, but it was published the same day as the OSHA ETS. It's kind of come under the radar and not gotten a lot of as much publicity as the OSHA ETS, but still is important for our discussion today. The focus of our discussion is on these federal mandates. We just raise the specter if you are in multi-jurisdictions, multi-states. There are different states and localities that may impose additional testing or vaccination, masking, distancing requirements. We're not going to be covering those today, but just be aware of that if you have locations in multiple states across various jurisdictions.
Okay, so just by way of background, and I'm sure as many of you are aware, and for those of you who have heard me talk about this before, you know what's coming. Combating COVID-19 has been a key priority of the Biden administration since day one. On his first day in office, President Biden issued executive orders and initiated several actions designed specifically to accelerate and expand the federal response to the pandemic. These efforts accelerated and came together this summer with the emergence of the Delta variant and the impacts that it was having across society at large, especially with respect to unvaccinated individuals who, according to the experts, were hit most severely. As a consequence of the ongoing pandemic, but in particular in response to the Delta variant, the administration pivoted in the summer to a more aggressive strategy, beginning with the publication of the issuance of a fact sheet back on July 29th, which announced several new safety protocols, mainly for federal workers, as well as on-site employees of federal government contractors. But that worksheet or the fact sheet also teased out new vaccination testing and masking mandates and essentially culminated with the September 9th Path Out of the Pandemic Action Plan. So this Path Out plan, which was rolled out essentially on September 9th, set the stage for a number of significant policy developments aimed to dramatically reduce the impact of COVID-19, including the wide-ranging vaccination mandates that we'll be talking about today. Next slide. So the Path Out Action Plan contains 6 interrelated parts, including getting assurance that all those who can get vaccinated do so. That part obviously has led to much of the attention and controversy that we've seen over the past many months, and which is certainly a focal point of the rules we'll be discussing today. In addition to getting the unvaccinated vaccinated, the other parts components are further protecting the vaccinated, of course, keeping schools safely open, increasing testing and requiring masking, protecting our economic recovery, and improving care for those with COVID-19. Next slide. So there are a number of key parts to this Path Out plan, including 2 major presidential executive orders that became effective when they were signed, as Katie alluded to earlier, as well as 2 presidential directives calling on OSHA and CMS essentially to take specific action directly in response to the ongoing pandemic. So Executive Order 14042, which again we'll talk about in more detail later, applies to certain federal contractors and subcontractors, I should say. Executive Order 14043 applies to federal government workers. Most notably, both executive orders require employee vaccination. President Biden on September 9th also announced that OSHA would be tasked with issuing an ETS, an emergency temporary standard requiring vaccination or alternatively weekly COVID testing for the employees of any employer with more than 100 employees, and that the Centers for Medicare and Medicaid Services, CMS, as Katie mentioned earlier, would be required to mandate vaccinations for employees working at healthcare facilities that receive Medicare or Medicaid reimbursement. Next slide. So one of the things that Executive Order 14042 did was to direct this task force, the Safer Federal Workforce Task Force, to issue guidance to effectively implement the executive order. And they were tasked with doing so by September 24th. And they did so. Let me just back up for a minute and sort of explain to you how the task force came into being. So the Safer Federal Workforce Task Force was established by President Biden in one of his first executive actions after becoming president. He issued an executive order that mandated masking and certain things with respect to federal government workers. This executive order also created this task force. It's comprised of federal agency heads from across government, including the Office of Management and Budget, the Office of Personnel Management, which is basically the federal government's HR department, and others, the director of the CDC, the director of the Secret Service, and so forth. So getting back to the guidance document that the task force issued, there are three main components to the guidance. There's the vaccination mandate, the requirement to wear a mask and to follow the CDC's physical distancing guidance, and then the requirement that covered contractors formally create, to the extent that they haven't already, a formal committee or group or designate a person who then would be tasked with coordinating workplace COVID safety requirements. It's the task force guidance and any updates to that guidance that contractors are required to follow pursuant to the executive order, which itself doesn't go into a whole lot of detail with respect to specifics, but it's important to understand, particularly if you are or believe yourself to be a covered contractor, that the guidance and updates and FAQs, those are the things that are going to guide implementation and enforcement of the executive order mandates. And in fact, the guidance frequently asked questions, which were issued along with the guidance itself on September 24th, have been updated a number of times since September to address a number of compliance-related and practical questions as recently as November 1st. Now, I checked last night and this morning, they could have updated in the last few hours, but the point is that they continue to update and add to that guidance. So it's important to pay attention to those. Next slide. So the guidance mandates vaccinations and masking and distancing for all covered contractor locations and employees, except where a medical or religious exemption may be required on a case-by-case basis. It also requires that, again, organizations designate somebody to be in charge of these efforts, again, if they haven't already done so. Next slide. So this executive order is extraordinarily broad, and it's certainly intended to be. That was certainly the intention, I believe, of the administration in issuing this executive order, as well as the other directives and EO 14043. EO 14042, the Federal Contractor executive order, applies to contractor and subcontractor workplace locations and individuals working on or in connection with a federal government contract or contract-like instrument. Excuse me. As noted here, it applies to any new contract or contract-like instrument, as well as solicitations, extensions, or renewals of existing contracts or contract-like instruments for procurement contracts for services, construction or leasehold interest in real property contracts, SCA covered services, concessions, and contracts offering services in connection to federal property or land or lands. It's important to note as well that this executive order, again, intentionally sets a floor, not a ceiling, meaning that it's not intended to, and by no stretch of the imagination, will prevent states or localities from imposing more stringent COVID-19 related safety requirements on private businesses. Perhaps more importantly, it seeks also to preempt state or local laws that purport to curtail or outright ban vaccination, testing, masking mandates, or other safety protocols that the federal government believes should carry the day. So obviously that aspect of the executive order and the other mandates that we're talking about today have become a major issue in pending challenges. Next slide. There are some things that the executive order does not cover. So the executive order does not apply to federal grants, to contracts with Indian tribes, to contracts or subcontracts whose value is equal to or less than $250,000, which is classified as the Federal Acquisition Regulation Simplified Acquisition Threshold. It's part of a regulatory scheme that is applicable to the federal government procurement process. And it's a number that's established by regulation. So this executive order doesn't apply to contracts that fall below that threshold, nor does it apply to employees who are working outside of the United States or to subcontracts solely for products. Next slide. So the big piece of this pertains to the vaccination requirement, obviously. The vaccination requirement applies to all full and part-time employees who perform work on or in connection with a federal contract or contract-like instruments. And to that point, that term, contract or contract-like instrument, it's a term of art that is defined in the task force guidance. And the guidance actually contains several key definitions that help us understand and appreciate, again, the intended breadth and scope of the executive order's applicability. To that point, contract or contract-like instrument is currently defined as an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable at law. Not, much to it, but certainly broad. The FAQs also importantly explain that in connection with a covered contract includes essentially back office and administrative functions like HR, accounting, and quote unquote legal review, which is actually included verbatim in the task force FAQ in question. So with that preview, and I know it's a loaded one, with that preview, let me turn it over to Katie to lay the foundation for our discussion about the two most recent federal mandates, the OSHA ETS and the CMS interim final rule. Katie?
Thank you, Ray. So the first one we'll talk about is the OSHA ETS that pertains to employers with 100 or more employees. And on a basic level, and we're going to discuss the kind of more the nitty-gritty details in a bit, but this particular ETS is mandating for employers that they have a mandatory employee vaccination policy or a policy that, although requires mandatory vaccinations, would permit weekly COVID-19 testing as well as masking as a condition for unvaccinated employees to enter the workplace. There are some fairly detailed collection and employee record retention requirements under this particular ETS, and certainly, a little bit of complexity and burden placed on the employer in terms of the records that would need to be kept for OSHA's review at a subsequent date. Interestingly, the ETS requires the employer provide paid leave both to obtain the vaccination or to recover from any adverse side effects once the vaccination has been administered to an employee, but does not require that the employer pay for the time off, does not on its face require the employer to pay for the time off if an unvaccinated employee opts for the weekly testing requirement. And then there's some reporting requirements and, of course, removal of affected employees that are spelled out in that particular ETS. As you mentioned, it applies, next slide, please. It applies to employees or employers with 100 or more employees at the time the ETS is in effect. It doesn't matter if all of your employees are not at the same location, as long as your entire business has 100 or more employees, full and part-time. On its face, this particular ETS, if you are covered, is kind of what I call the waterfall effect of choosing which particular mandate that you are required to cover if you're covered by both. If you're covered by the Executive Order 14042 that Ray has just described, you are supposed to comply with that first, and you don't need to comply with the requirements of the OSHA ETS. If you are a covered entity that was covered, and I mentioned this earlier, covered by the June 2021 OSHA ETS relating to healthcare facilities and healthcare providers, you do not have to comply with the OSHA COVID-19 ETS. Different from the executive order, while you may as an entity be covered by the ETS, if you have remote workers who, and then, if everybody has been shipped home and you haven't brought them back to your facilities yet, and if they're truly remote workers and are not coming into the office, the workers themselves are exempt. You would still have to count the workers as your employee count, but the workers themselves would not need to be subject to either the vaccination or weekly testing requirements. And if you have employees who work exclusively outdoors, they are also exempt from the requirements to be vaccinated or provide the weekly testing. Next slide, please. So the compliance dates are twofold, they're two-tiered. One is December 5th of 2021. That means that for all but the testing requirements, meaning you have to initiate the record keeping obligations, you have to require masking of your employees who are unvaccinated, and all of the other requirements that are part of the ETS need to go into effect by December 5th, with then the testing requirements in effect as of January 4th of 2022. Next slide, please. So, as I'm sure most of you have heard, literally on the day the order came out or the regulation was published, there were legal challenges filed in the 5th, 6th, 7th, 8th, 11th, and DC circuits, and basically challenging the regulatory, that the regulation exceeded the scope of OSHA and the federal government in coming out as an emergency temporary standard without going through predominantly the rulemaking process required by the Administrative Procedures Act. Now, the Fifth Circuit on Saturday, literally the day after it was filed, did enjoin, or we're calling it temporarily enjoin the rule, at least with respect to businesses covered in Texas, Louisiana, and Mississippi. Although it's a little unclear because the Fifth Circuit's order said that it was issuing a stay based on the motion that had been filed by the petitioners. And the petitioners, although localized within those jurisdictions, did seek a nationwide injunction. So it's a little bit unclear on the order exactly how far the reaches of that stay go into effect. Biden administration, though, filed a response yesterday, and there's a reply brief due today. Now, the interesting part about this is, will the Fifth Circuit retain jurisdiction of this particular mandate? There has been a letter filed with the multi-district litigation, system where there will be a blind assignment because of all these cases, if it's accepted, and these cases are pending in all these circuits. So it's possible that that all of these challenges will be consolidated in one of the circuits that it's pending. Could be removed from the fifth, at which point, the court that gets it can, take away the stay of the mandate, keep the mandate. I mean, so it still remains to be seen, and we'll be, looking at that over the next few days and weeks at the rate this is going. But right now, it's the rules at least temporarily stayed in Texas, Louisiana, and Mississippi, with a kind of question mark about, how far that the mandate, the stay goes. And go ahead and next slide, please.
Okay, so I think at the outset, it might be helpful to know that the actual ETS, so the rule itself, makes up only 5 of the 153 pages that were actually published in the Federal Register last Friday. The pre-publication document was significantly longer. It was 400 pages, but the point is that the bulk of the publication contains the agency's lengthy and really detailed discussion of the legal and practical purposes, underpinnings, and justifications for issuing the rule, no doubt anticipating all of the legal challenges that it is now facing that had been threatened from the moment that the idea of this ETS was first made public. So the main justification, really boiled down, consists of 2 objectives. One, to encourage vaccinations as the most effective means of protecting unvaccinated workers from quote unquote grave danger associated with possible COVID-19 infection, particularly again in light of the Delta variant, which the agency explains in the preamble has hit unvaccinated individuals especially hard. And I will just say that grave danger piece is important from an enforcement and enforceability standpoint. There are certain criteria that OSHA has to meet in order to justify issuing an emergency temporary standard that has not gone through formal notice and comment rulemaking pursuant to the Administrative Procedure Act. So that use of the term grave danger is intentional, and it's meant to, as a counterpoint to the arguments against the ETS with respect to overreach. So that's the first objective. And certainly to that point, the second objective is to make clear that state and local efforts to restrict, prohibit, or get around compliance with the federal rules will fall, at least in the administration's view, on preemption grounds. Next slide. So there's a whole lot to the ETS in terms of specific requirements. The ETS imposes essentially 7 major requirements on covered employers, beginning with supporting the federal policy on vaccinating the unvaccinated. So under the ETS, employers have to develop a mandatory employee vaccination policy, okay? But as what is characterized as an exception to that requirement, employers also may alternatively, and this is the piece that we've heard most about, alternatively adopt a policy that allows employees to either produce proof of a vaccination status, in other words, get vaccinated, or submit to weekly COVID-19 testing and adhere to other safety protocols, namely wearing a face covering, generally at all times while indoors at work. Interestingly, the ETS contains a definition of mandatory vaccination policy, which specifies that the employer's policy has to mandate vaccinations to the extent that you're going with option 1, the mandatory vaccination, no testing requirement piece, that the employer has to mandate vaccinations for all current employees as well as new hires as soon as practicable, allowing for only narrow exemptions for individuals for which the vaccine is medically contraindicated, where a delay in getting vaccinated is justified by a medical necessity, or where the employee is entitled to an exemption as a disability or religious accommodation. Next slide. The ETS also requires employers to determine the vaccination status of their employees, meaning that they actually have to identify who's fully vaccinated, who's partially vaccinated, and who's not vaccinated, unvaccinated at all, not vaccinated at all, and also keep records of that information, which we're going to discuss later. It's not, sort of your ordinary run-of-the-mill documents, and there are consequences and implications, compliance implications associated with how and to what extent an employer collects these records and keeps them. So part of the requirement, again, is to collect proof of vaccination status. Like the executive order, the ETS outlines the form of acceptable proof of vaccination status as outlined here. They're essentially the same forms of proof that are called for under the executive order. But let's go to the next slide. So unlike the executive order, the ETS does permit employers to accept an employee attestation of vaccination status as proof under limited circumstances where, for instance, the employee has lost their proof or cannot access it or otherwise obtain proof that they were in fact vaccinated. The attestation must be signed and dated, and it has to include a statement, and the statement is in the ETS itself that's here on the slide. The statement has to affirm that the employee's attestation is true and accurate, and has to acknowledge, obviously, that knowingly providing false information could result in criminal penalties, which, by the way, could include jail time under the OSHA Act. So to the extent that they can, the ETS said that employees should also include information, this is not mandatory, but they should include information about which vaccine they received and when. But obviously, if you have somebody completing the attestation saying that they don't have access to their proof of vaccination status, they may not be in a position to provide this information. Next slide. Okay, so with respect to vaccination verification, not only must employers retain a record of each employee's proffered proof of vaccination status, but they must also maintain a roster that lists all employees and indicates each employee's vaccination status. So for those who are listed as unvaccinated, the roster has to indicate whether it's because of a medical or religious accommodation or because they didn't provide acceptable proof of vaccination status. As we'll discuss in a few minutes, both employees and their representatives, as well as OSHA, will have rights of access to some of this information. So again, I think the record keeping piece to me of this ETS is potentially most burdensome if you're not prepared for it. Next slide.
Ray, quick question. We had a question that's come up in the Q&As about whether, because remember that remote workers are exempt from having to either be vaccinated or show proof of weekly, but the question is, does the employer still have to document, find out is the worker vaccinated or not as part of the record keeping requirements?
That's a really good question. It's unclear in the preamble and the rule itself whether and to what extent a remote worker who works entirely from home has to be included in the roster because they're not subject to the testing or vaccination mandate. But if you have a remote worker who spends any time in the office, even 1 or 2 days a week, or sporadically, maybe 1 or 2 days a month, that person, before they'll be allowed to enter the workplace, will have to submit to the testing requirement if they're unvaccinated if they haven't provided proof of vaccination status. And once that happens, they have to be included on the roster. And by the way, and we're going to talk about the record keeping a little later, the information that you have to provide, for instance, on request to either OSHA or to an employee or an employee's representative includes aggregated data with respect to number of vaccinated individuals, as well as the number of total employees. So if you have 150 employees and you've got 85 who are vaccinated, you don't have to provide the actual roster, but you have to actually include the number of vaccinated along with the number of total employees. So that invariably would include your remote employees, if that makes sense.
And it would seem to be that with OSHA being really sort of the floor, or the floor for the requirements, absent some sort of prohibition in, that would, in other areas, I wouldn't probably make more practical sense to request, because I know from the EOC's perspective, you can request the vaccination status of your employees and know what it is, even if you're not requiring the employees to be vaccinated or not.
Right, and an individual might be working remotely because that's just the nature of the job. It may not necessarily indicate that they're working remotely because they cannot provide proof of or refuse to provide proof of vaccination status, right?
Right.
So on this slide, providing support for vaccination, this is, Katie teed this up earlier. The preamble really goes into great detail about this, and it provides that an employer, it talks about the requirement that the employer provide reasonable time to obtain a vaccination. So essentially what the preamble provides is that reasonable time in this context means essentially up to 4 hours of paid leave per each primary vaccine dose. So if I'm an employee and I'm going for my first COVID shot, the ETS would obligate my employer to provide up to 4 hours of paid leave time for that purpose. And then I would be entitled ostensibly to another 4 hours when I go back to obtain my second dose. But here they're talking about primary vaccine dose. So if I'm immunocompromised, as an example, and I am eligible to obtain a booster shot, that's outside the scope of this particular requirement as I read it. A couple of notes to make here. The 4 hours of paid leave time includes travel time, and it must be paid, as explained in the preamble, at the employee's regular pay rate. As Katie said as well, the regulation requires, or the ETS requires, that you provide reasonable time and paid sick leave for side effects as a result of having gotten vaccinated. The preamble actually is very helpful in this regard. It provides that if an employer makes up to 2 days available, then the employer would be considered in compliance with this requirement. So the ETS and the preamble is essentially saying that effectively 2 days is the benchmark for determining what constitutes reasonable time. Other helpful information out of the preamble is that it specifies that employers may require an employee to use accrued sick time, and also set a reasonable cap on the paid sick leave that the individual uses, again, using that 2 days as a benchmark. Finally, the preamble notes that additional time may be needed on a case-by-case basis. There may be an extraordinary instance in which someone suffers for 3 or 4 or 5 days as a result of having had an odd or unusual reaction to a vaccination. What the ETS provides is that you don't have to pay for that time beyond sort of reasonable time, but any unpaid time off related to basically recovery from the effects of a vaccine are considered protected, job protected. Next slide. So The COVID-19 testing piece of this requires that anyone who has not provided proof of vaccination status or is unable to be vaccinated must submit to weekly COVID-19 testing. So they have to provide the results of a COVID test every 7 days, at least with respect to those people who are in the office at least once per 7-day period. Okay. If you're not in the office as regularly, you have to provide proof of a COVID negative test, essentially, at least 7 days before you come back into the office. And employees who fail or decline to do so are not going to be allowed into the workplace unless and until they produce a COVID-19 test result. As Katie mentioned at the outset, employers are not required to pay for testing unless they're otherwise required to do so by law, for instance, as part of a disability or religious accommodation, or perhaps because this was something that was negotiated as part of a collective bargaining agreement. Next slide. The ETS actually defines what a COVID-19 test, and I think it's helpful as a practical matter because obviously questions can and will arise with respect to what constitutes an appropriate COVID-19 test. So it's defined in the rules as a test that is FDA cleared, approved, or authorized to detect current COVID-19 infection. It is administered in accordance with the authorized instructions, and this is the, I think, most important part from a practical perspective, is not both self-administered and self-read unless observed by the employer or an authorized telehealth proctor. So what that means is that an employee can't go purchase an off-the-shelf test, self-administer it, and then produce the results of that test without having gone through typically for the at-home test, there's an opportunity to have those results proctored, the test proctored, and those results confirmed by an authorized proctor. Some examples that are include obviously lab process tests, those proctored over-the-counter tests, point-of-care tests, and then tests finally where the specimen collection and processing is either done or observed by an employer. So the employer obviously has the option of taking on this task itself. Next slide. The fifth major requirement is with respect to notification and removal requirements. So employers have an obligation to require their employees to notify the employer of a positive COVID-19 test or diagnosis. So obviously this would be, and this applies without regard to vaccination status, right? You might have a vaccinated employee who gets a breakthrough infection. That person, pursuant to the policy that's required under this ETS, has to promptly inform the employer of the positive diagnosis or test, and as soon as practicable, and that employee has to be removed immediately. And the employee won't be allowed to return to the office until they've either cleared the CDC recommended isolation guidance then in effect, or have been cleared by a healthcare professional, or interestingly, if they take a negative confirmatory test, the NAT test, they produce a NAT test result following an initial positive antigen test. So the NAT test is more sensitive and more accurate than the antigen test. And so it might be able to detect false positives, essentially. And again, as Katie said, the employer is not required to provide paid time off for COVID infection itself. Next slide. So there's certain information that the employer, as I alluded to earlier, has to provide to employees. Employers have to inform employees of all of the requirements under the ETS, as well as and including the company policy that's developed pursuant to the ETS. It has to be provided in a language and at a literacy language understandable to the employee. So that's going to vary from business to business and maybe even location to location, depending on the nature of your workforce. You also are required, if you're covered by this ETS, to provide information on the benefits of getting the vaccine, the efficacy of the vaccine, and you must provide your employers with a copy of the CDC's key things to know about COVID-19 vaccines, and the link is provided there. Importantly, of course, you have to remind employees of their protections, legal protections against retaliation for exercising their rights under the ETS or the OSHA Act, or for making complaints thereunder. And then you also finally have to inform employees of the criminal penalties associated with knowingly supplying false statements or documentation. Next slide. Record keeping and reporting. Again, we covered this a bit. The employer has to report fatalities and hospitalizations very quickly. So all work-related COVID deaths have to be reported to OSHA within 8 business hours. Hospitalizations have to be reported within 24 business hours. With respect to accessing records, employees are entitled to, or their representatives are entitled to, request and receive by the end of the next business day following their request information about their own COVID vaccination documentation or test results, as well as I mentioned earlier, the aggregate number of fully vaccinated employees at a workplace, along with the total number of employees at that workplace. And then OSHA has the right to demand access to your written policy pursuant to the ETS, and that same aggregated data within 4 business hours of making the request. And obviously this is a really quick and efficient means of enforcing compliance. Let's move on to the next slide. Katie, I think you're going to take it from here.
I will give you a little bit of break. And frankly, the CMS gave healthcare providers a bit of a break because the rule did not encompass as many pages of preamble, nor as have the complexity that the OSHA ETS for employers of 100 or more employees have. And it's different. And we mentioned in the beginning that that OSHA issued an ETS for healthcare providers and facilities back this summer. And again, this dealt really with general workplace safety issues for healthcare workers in the prevention of the transmission of the disease, employee training, and overall workplace safety issues that included everything from ventilation to cleaning, and again, sort of an overall workplace requirements. And the idea was to promote vaccinations back, this summer within the healthcare sector. And to do that, it mandated that the covered healthcare providers would be required, like the OSHA ETS, the current OSHA ETS, pay time off for obtaining the vaccinations or for dealing with the side effects of the vaccines. But what happened was, the idea was to promote more of the vaccinations across, at least the healthcare sector. But again, Delta variant hit. The number of vaccinations, even with the OSHA ETS enforcement of and the promotion of the vaccines, wasn't quite getting the work done. And so President Biden, as we mentioned earlier, outside of OSHA, went to CMS, which is the Center for Medicare and Medicare Services. And this is the federal agency that's overall responsible for the health and safety standards known as conditions of participation and coverage for 21 types of healthcare providers. And if we go to the next slide, we'll see some of the healthcare providers that are part of this CMS rule. Now, the CMS, as I mentioned earlier, did not include all 21 of the entities, but it covers everything from an ambulatory surgery center, home infusion therapy suppliers, mental health centers. Then we go to the next slide. And then, your typical, what you think, hospitals, home healthcare agencies, hospices, long-term care facilities, those types of entities. And so these are folks who are receiving, significant federal dollars in Medicare and Medicaid reimbursements. And therefore, as part of CMS's rulemaking and it's part of its authority, has an ability to implement safety regulations for these various healthcare entities. Now, the interesting thing about the CMS rule, and we'll go to the next slide, is that it exempted out certain organizations that they do cover as part of reimbursement, and includes these here: the religious non-medical healthcare institutions, organ procurement operations, and the such that are listed. The one thing that, even though an individual medical practice will receive Medicare and Medicaid reimbursement from the government, this particular CMS regulation has exempted out individual physician offices. And that's kind of I think a fairly key provision. And it may just have to do with the size. They're trying to really focus on the larger healthcare providers and coverages. Now, again, that doesn't mean that certain physician practices, if they're not covered by the CMS regulation, won't be covered by the prior OSHA ETS, or if you're a large enough practice and you have more than 100 employees, you would be covered by the OSHA ETS. But as a practical matter, individual physician offices are not covered by the CMS requirement. Now, where it gets complicated is for those physician practices that are also affiliated or have an affiliated ambulatory surgery center. And because the way the CMS rule kind of governs those folks that are covered, not only employees, but all of those that are covered as part of who must comply with the vaccination requirements, that if you are a practice, for example, orthopedics does this a lot, you will have a practice side who covers sort of the day-to-day physical therapy, occupational therapy, and then physician visits. But there's a separate entity that's affiliated that has an ambulatory surgery center, and you have an awful lot of trade-off with staff. You have administrative staff that service both. You have leadership that services both. And if that is the case, your physician office may not, you may still be covered by the CMS rule because of that sort of what I'll call cross-pollination. And that's because, we'll go to the next slide, CMS has basically required vaccinations not only for employees of these facilities. So they have a much broader reach than at least the definition, I think, of who is an employee from the OSHA ETS. But the vaccination requirements are facility driven, not employer driven. So when you look at who's in the facility, so obviously facility employees, and that includes, even if you're not a healthcare provider, it could include your housekeepers, your maintenance, your food service folks. If they're part of the facility, they have to be covered. If licensed practitioners, for example, in a hospital setting, if you have staff physicians who have privileges, they are not necessarily an employee of that facility, but they come into the facility. Those practitioners must be covered. So students, and if you bring in students, if you're a teaching hospital, the students must be covered. Your volunteers must be covered. One of the interesting points is it will even cover, because of the fear, and in the CMS context, it's fear of transmission in healthcare settings. It will cover, for example, if you have a fiduciary board over a hospital, over a hospice, or over an entity. They're not necessarily medical providers, they're not providing medical care, but because those board members are dealing with the administrative staff of those facilities, and again, from board member to administrative staff downstream into any worker within that facility, they will be covered and expected to be part of the vaccination process for the CMS facilities. Like the OSHA OTS, though, they do exempt out any staff who completely work remotely through telework environments, as we discussed earlier. Now, next slide, please. So the CMS requirements are not so much there's not a lot of devil in the details, if you will, in the CMS obligations. What they expect is the entities, the facilities themselves, to implement plans and processes. And they're in kind of, they have a number of them, but they all sort of fall in kind of three general areas, which is to implement a plan for making sure that all eligible staff, and staff again as defined, broader than an employee, for vaccinating, for obtaining the vaccinations. There has to be a process in place for allowing employees to seek exemptions for the medical contradictions, the disability exemptions, or the religious exemptions that we talked about, like similar to the other requirements. Interestingly, the CMS requirement for the health facilities is a little bit more specific about the documentation for the medical exemption. And they mandate in the regulation that any medical contradiction or medical exemption, disability-related exemption, must be verified by a licensed provider acting within the scope of their practice. And then they must provide, and then the regulation is pretty detailed about the level of specificity that must be in the medical documentation for the exemption from the CMS requirement for these healthcare facilities. And of course, you have to have processes, similar processes, although not quite as detailed and onerous as the OSHA ETS, to track and document the staff vaccination status. Unlike the OSHA ETS, the CMS requirement doesn't have an employer or an employee ability to get aggregate data, or employee requirement to show your employees the information. But there is certain tracking requirements, I think, that CMS already requires of the healthcare providers, and they would ask for that. So the requirements, we say they're similar to OSHA ETS with respect to documenting the vaccination status, but doesn't have a lot of the other reporting requirements that Ray mentioned earlier. So again, a little less onerous obligation, putting it more in the hands of the facilities themselves without dictating a lot of specificity as to what's required. Go on to the next slide. Unlike the OSHA ETS and similar to the federal executive contractor order, the CMS IFR does not permit a testing option for unvaccinated staff, meaning that there is no unvaccinated staff unless you can meet any of the disability or religious exemptions. But in the meantime, while the testing obligations and in general, the CMS rule does discuss and emphasize more of other measures of, again, infection control, physical distancing, and protecting unvaccinated workers in the meantime as this particular regulation is implemented. Go to the next slide. Purpose is, again, I mentioned the sort of the waterfall effect. We really start out with the CMS guideline, and from CMS's perspective anyway, if you are one of those 15 facilities and are otherwise covered under the conditions of participation and receiving Medicare and Medicaid funds, then your first obligation, and really your main obligation, only obligation, is to comply with the CMS requirements. So you're not required, if you meet the CMS requirements, you are not required to then follow the executive order, and you're not required to follow the OSHA ETS for 100 or more employees if you're also covered by that. If you're not covered under CMS, so the next level is that you're either a federal contractor or covered by the prior OSHA standard. And if you're not covered by either of those, then you fall to the OSHA ETS. So that is the pecking order if you happen to be an entity that is covered by multiple prongs of these regulations. And I think then, Ray, we'll turn it over to you on the deadlines.
Okay, next slide. So we'll move fairly quickly to this. The most important thing to take note, particularly for those of you who have been tracking this, is that there's a new compliance deadline for obtaining vaccinations, for employee vaccinations. That is January 4th, 2022. That was published in a fact sheet that was issued by the White House when it was in the process of publishing the ETS and the IFR. It's done so in order to make it less complicated on businesses that may have had overlapping vaccination requirements. So they wanted to just create conformity across the executive order, the ETS and IFR, make it easy for businesses and workers to comply and so forth. Next slide. So we've talked about this again. The ETS has been enjoined in at least one jurisdiction. No challenges so far to the interim final rule. And with respect to the executive order, there have been challenges brought to that, but no injunctive action has been, no injunctive relief has been offered or granted to date. And I suspect that it would be a bit more challenging to oppose the executive order, or perhaps the ETS might be a better, more ready target for immediate injunctive relief. But there's plenty of time still yet to figure out what happens there. Next slide. So on the question of preemption, the task force guidance and the OSHA ETS and the CMR, all of these federal mandates address that issue head on and make clear that the administration's intention is to preempt any state or local laws that seek to undercut or purport to override the federal vaccination mandates. Next slide. And this is the language that's contained in the ETS. And the next slide contains the information that is contained in the IFR. Katie, anything more you want to say on this?
Yeah, just that similar to the federal regulation, the CMS understands that that there are states that are trying to impose restrictions on the ability to have vaccination mandates, and CMS is taking the position along with everybody else that we're the federal government. This is our area of control, and from the CMS perspective, theirs is a much narrower coverage, and within the scope of presumably within the scope of its responsibilities. And so the challenges are going to be a little bit harder and steeper, I think, for a CMS challenge on these. I do want to address, I know we are getting questions fast and furious. We are looking at them as we're going through, but we're trying to get through the material. But one of the questions from one of the participants is asking about how does HIPAA come into play in all of this? And I don't know the exact, there was no real context to the question. In general, from the OSHA ETS for private employers, understand that HIPAA does not apply to private employers. It is a federal statute that governs medical records of patients or the medical information received by a healthcare provider or a healthcare plan in its role as healthcare provider or plan. So even a hospital in its role as an employer, isn't necessarily holding employment records in a HIPAA context. So that's sort of a general conversation or context for HIPAA. And then certainly with private employers, if there's medical information that is contained in the vaccination cards and things, that is not considered covered by HIPAA. You'll be subject to ADA confidentiality provisions as an employer, but it's not subject to HIPAA. So I wanted to bring that up just as sort of a kind of a conflicting, it's not really a conflicting state or local law, but just make sure we address that question. Also, as a side, just to make sure all participants know, everybody will be receiving, if you've registered for this seminar, you will be receiving the slides. All right, next slide, please. So what's the upshot with everything, with the challenges and things that are going on? Certainly, if you are subject to the CMS IFR or the executive order 14042, you should be planning to comply and as planned. Although there are challenges to the federal EEO or the federal EO, that a federal executive order has more weight from almost a statutory weight to a degree, a little bit harder to challenge. So the likelihood, it could be challenged, it could be upheld, we just don't know. But those are going to be harder uphill battles than just agency action, some of the agency action challenges for the OSHA ETS. And again, there has been no challenge currently to the CMS, and it is part of CMS's role in the Medicare Medicaid world. Again, more narrowly tailored. And Ray, you want to talk about the ETS?
Yeah, as for the ETS, there's a chance that it's ruled unenforceable entirely or in part, but also maybe even an equal chance that it's upheld in part or in whole. So particularly because of the extremely strict record-keeping requirements in and of themselves, not to mention the rest of the rules requirements, it's really important for covered employers to be planning ahead now for how they're going to implement these requirements. I will say that OSHA has published some guidance and some sample policy language on its website, but even if you use that as a starting point, you'll obviously want to customize it to fit your organization and, of course, run specific issues by your legal counsel and so forth. So it's good to know that those resources are out there, but you'll probably need to do some more planning in anticipation of the rule perhaps going into effect. Next slide. So we wanted to talk a bit about disability accommodation issues. In the interest of time, I think we'll just move on and just essentially emphasize that in dealing with COVID-related disability accommodation requests, you want to think about it as you would any other ADA reasonable accommodation request and process. You're looking at these requests as individual requests and considering them on a case-by-case basis. There is no one-size-fits-all when it comes to disability accommodations, and to a certain degree as well, religious accommodations, although the standards with respect to undue hardship are different under Title VII than they are under the ADA. But I would just commend you to use the interactive process that we all are accustomed to using in evaluating disability accommodation requests that arise in the context of COVID-19. Katie, do you want to say anything more about that or religious accommodations before we wrap?
Sure. Maybe we jump to, I think it's slide 5051, Emily. Under Title VII, obviously there is the general duty to accommodate sincerely held religious beliefs, and these laws and these requirements, as Ray said, are supposed to be done on an individual basis. And pre-COVID, and in a normal, if you call the old normal world, these would come up really on an individualized and ad hoc basis, and probably not, particularly in the religious arena, not too often for employers. So it was relatively easy to deal with. You had an employer request time off for not working Saturday as a religious accommodation. And when you look at it as a whole to your entire organization, depending on all the factors, you can make that determination. What COVID has done is, unfortunately, that none of the federal guidance has provided any more specificity as to what needs to be considered with respect to religious and medical accommodations. They have deferred to the EEOC, which again was not designed for this sort of mass vaccination mandates where, for some employers, they may get 500 religious accommodation requests within a short period of time if they implement a mandate. So it causes, obviously, practical issues. I will say that at least from the CMS perspective, the only inkling we got was this idea that one of the considerations in evaluating an undue burden on an organization with respect to religious accommodations and even medical, but predominantly the religious, is not only just the cost for that individual employee, but the impact on the organization and the organization's role as a healthcare provider, and that certain decisions can be made, including, in theory, placing employees on unpaid leave status because you cannot accommodate them, given and again, in part dependent on the number of employees who are requesting it. These are really complex issues, but understand that it's by design. You still have to go through the process and have processes in place, but what we've seen in litigation, at least with respect to private employer plans, is that the courts have been more acceptable of the sort of burden on an organization when you have large masses of folks who are requesting religious accommodations. That doesn't mean that as an employer, the first 5, if you think you can accommodate that request, that you have to make those accommodations. But as 5 becomes 15 or 50, it may be harder for you to do it down the road. And just because you made an accommodation for one person doesn't mean person 50 has to get the same accommodation. So that we could probably spend an entire hour on the accommodation process, and wish we had more time on that, but we'll kind of end on that note.
Well, the one other thing that I will just mention is that, again, going back to the task force guidance, the guidance was updated recently to talk about medical exemptions and to provide covered contractors with greater flexibility with respect to issues like temporary accommodations, pregnancy, temporary exemptions related to pregnancy or other medical contraindications. So I would commend those guidance FAQs to you for light reading.
Ray, I was hoping we may not have a lot of time for a lot of questions, but one that I saw repeatedly come up, and I don't know if you know the answer to this, is in the testing. In the OSHA ETS, which provides for weekly testing, are COVID rapid tests acceptable?
I'd have to go back and review the definition of a COVID test that's in the ETS. I think there's generally some flexibility as to what tests will be acceptable. The only inflexibility is with respect to whether it's self-read. So if a rapid test is administered by a healthcare facility or a provider or a proctor, then that's acceptable. What's unacceptable is a rapid test that the employee buys, takes on his own, doesn't sign into the website to have the result proctored or have the result read by the employer, and then tries to submit that.
All right. Okay. And I'm not sure if we have time for any other. There's a question about the ETS does not address contractors in the private sector. Do you have any guidance as if it applies to private sector contractors? The way I interpret that is, are you talking about whether, if this question is going to whether the OSHA ETS for employers of 100 or more employees would apply to independent contractors that are covered? Do you know, does the ETS address that issue?
I didn't see anything that addressed that issue specifically, but there is a definition of employee, I believe, and my guess would be that independent contractors, 1099s, would be excluded. But I'd feel more comfortable verifying, and I can certainly follow up with the person who's asked that question. Right.
The question goes to ETS, but from CMS's perspective, if the facility, again, the CMS focuses on the facility, not who is the employer. So if as a facility you are bringing in a contractor, for a regular basis, those contractors will need to be covered. The only examples they give you is, for example, you have an emergency plumbing situation, you have to bring in a plumber to fix that one emergency. They said we're not saying you have to do it for that person who is, because they're a contractor, but they're not there for, you can do other things to segregate them off. But if you are there for, you're building out a piece of your facility, and they may be interacting and walking through the halls with your employees on a regular basis, then yes, those contractors would have to be covered.
Well, we've hit 4:15. I think that we've overstayed our welcome. On behalf of Katie and myself, thank you all so much for sticking with us and for participating. As we said at the outset, we're going to make all of our materials available to participants, and certainly welcome any questions or follow-up that you have, especially with respect to material that we were not able to go into depth on in this session. So with that, I just thank you very much and wish you a good and productive afternoon.
Thank you.